going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Hope you guys had a great weekend. Yeah, I had a good weekend. I hope you guys had a good weekend. All right. You want to watch some court? I want to watch some court. This is another one of those random clip nights. The first one is an HOA hearing, and I personally find it hilarious. But yeah, so we're going to start with that one, and then we're just going to be bouncing everywhere. I've got a little bit of everything for you guys tonight. Yeah, that's all for the intro I have. All right, before I hit that play button, you guys know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
And counsel, what is your case? And you are representing who? Okay, come on up. And then we'll do counsels for Darwin and y'all. Let me get Anthony on this side and Ms. Hill and counsel on this side.
Your Honor, I have a binder for you.
Okay.
Heather.
Yes, ma'am. And then counsel, is there any pretrial hearings or motions that we need to discuss?
Yes, Your Honor, that's jurisdiction.
Okay. All right, so Mr. Anthony, real quick, what I'm gonna do is I'm gonna let counsel speak. She's got a pretrial matter, which means she's got an issue before we even start. Okay, and her issue is something about a plea to the jurisdiction. So I haven't heard it yet, but in other words, something wasn't done correctly for me to hear this case in this court. And so I got to hear what she says. Once she lets me know, then I will let you respond. And then we'll decide if we're going to dismiss it, if we're going to let you amend it, or what our actions are that we're going to do. Okay. Go ahead, counsel.
Good morning, Your Honor.
Morning.
So before I get into the content of the actual plea, I'm just going to give Your Honor I'm going to zoom out, give Your Honor kind of a 30,000 foot view.
Okay.
So the underlying issue that Mr. Durazio has filed suit about is a vote that was conducted at the association. This is a condominium association. My client, Ms. Hill, is a homeowner, as is Mr. Durazio. My client, Ms. Hill, is also on the board of directors. But the vote in question that Mr. Durazio is complaining of was not a vote of the board of directors. It was a vote of the members, of the homeowners individually. So, as Your Honor is aware, before we can have a trial, the court has to have jurisdiction. One of the primary factors of jurisdiction is that the complainant, which here is Mr. Durazio, has to have standing. Unless there is a live controversy before the court, as in the person who has been sued is the one who conducted the actual injury, the complainant does not have standing. And that's the issue that we have before the court. This was not a
Rich. Happy birthday, Rich. I hope you had a great day. Well, hold on. He's in the future. Is his birthday the 19th or the 18th? Which one is it? Is it actually our today or his today? Because I guess either way, happy birthday, Rich. And thank you so much, Shadow, for the super chat. But happy birthday, Rich. And HCC, welcome to the family. I feel like you already were a member, but oh well. It's thank you so much. Thank you so much, Hector. I appreciate it. Hold on. Rich responded 19th. Okay, so technically it's tomorrow for everyone else that's not in the future. For all of us people in the past, it's your birthday tomorrow, but it's your birthday right now for you. So happy birthday, my friend. Enjoy your day. I hope you have an amazing day.
Ms. Hill is an individual homeowner. You can't sue individual homeowners just because you don't like their votes. The association called the vote. This was a vote for the association. The members at this vote approved these that certain painting be assessed and that the homeowners would contribute to that. That wasn't done by my client individually. That was the homeowners collectively. So there's no injury. And additionally, this is the second time that we've been in this very court on this exact same issue. So this vote was back in 2022. Mr. DeRazio first sued the former board president, Ms. Stephanie Weiss. And if you look at his current petition and the petition that was filed a couple of years ago, it's verbatim. There's just less causes of action this time. The only one before the court is for breach of the declaration, but it's like copy paste. Last time, the court specifically instructed Mr. DeRazio that it did not have jurisdiction. It granted our plea. My law firm defended it. And the court specifically told Mr. DeRazio, and I quote, "You should have sued the association." So we've done this before. Mr. DeRazio was told he can't do this before, and he did it again. So what's really happening is Mr. DeRazio is going from board member to board member to board member to board member and filing suit. And therefore, because this was done in bad faith and knowingly, in addition to asking the court to dismiss this case for lack of jurisdiction, we're asking that the court use its discretion to deter Mr. DeRazio from doing this again tomorrow against the next board member and award us our attorney's fees.
Okay,
And I
talk to me
provided
about-
a attorney's fees affidavit for your honor.
And what number is that, counsel, on here? Well, I guess I should look at it right.
Well, I think it's 1884, your honor. I'll double check for you.
And then while she's doing that, go ahead, Mr. Anthony.
I disagree on the underlying issue, first of all, Your Honor. If you read the complaint,
All right, before he gets into it, I feel like Matlock was the defense, right? Yeah, I think he was. It's been a long time since I've seen that show, but I remember he got somebody out of. Wait a second. I'm still going with defense. Stephen Price, thank you for becoming a member. For some reason, it popped up twice. Not really sure how that works. So, but thank you twice for becoming a new member. I really appreciate it. Welcome to the family. Okay, let's keep going.
it's about a board member and fiduciary duties that they have and managing the HOA's governor's documents and the applicable laws. And that's what they went against. It has nothing to do with the vote. Matter of fact, I was looking at the complaint. I don't see where I talk about that in the complaint on the vote, other than they did have a vote, but the board members call the vote, number one. Number two, on the one with Stephanie Wise, actually, she resigned 2 weeks after I filed my lawsuit. And when Mark Robbie, the attorney that came in, he basically said, and it was a last minute motion like these are. And unfortunately, I was in Europe by the time I got it, and I was on one of these. I didn't have time to prepare. But basically they said, well, is Mrs. Wise a board member? And I said, well, she was a board member, but I couldn't prove it. So that's why it was dismissed, because she wasn't a board member. And as I stated, she resigned 2 weeks after I filed the suit. So if you go through this, it's a breach of fiduciary duties. And I believe in Texas ruling, board members have a fiduciary duty to act in the best interest of the HOA and its members. And if the court would hear what really happened, I believe you will see that. And I have writing in here from Mrs. Hill stating that the declarations are right, but they tried to do an end run, just like they're doing legal maneuvering today around that, and created a board, or I'm sorry, a member vote, which they have no right to do.
Okay, so hold on real quick. So what is the initial basis of your complaint? Is it due to?
Breach of fiduciary duty.
Yes, I understand, but that's not what you put here. You put incorrect vote and payment of painting.
I put in my complaint,
A limited common element as per article, definition of a limited common element of the Keith William Association declarations. Again, articles, it's stating articles, responsibilities. But initially is what I'm asking you is the basis of
That
your
was a-
vote.
yeah, that's true. Okay, go ahead.
It is due to, for lack of better terms, you're not agreeing with something that the that they have voted on. Is that correct? I don't care what it was that it was voted on, but according to your complaint, it's incorrect votes. That's your first word.
Okay, my first words are, this is a summary of the complaint. See complaint write-up for additional detail. If you see the complaint write-up for additional detail, it really doesn't. I summarized what that was. So in here, it talks about they should be held liable, the defendant should be held liable for not understanding the declarations and how they did it,
Okay,
how they
but
maneuvered it.
my thing is, why are you suing an individual board member and not the entire board? Because wouldn't she be accountable? If I'm gonna hold one accountable based on this, say you win this case and I hear all your story and I hold her accountable,
Mhm.
why should I only hold her as an individual accounted for and not the whole board member?
Some of the board members aren't even around anymore, Your Honor.
Okay,
The
but that
boards
didn't
have
answer my
changed.
question. Just because they're not around doesn't mean they're not liable and you get to pick and choose who you wanna sue. If she's gonna be responsible for the whole board,
Mhm.
then you would sue the whole board. That's,
Well,
like-
this defendant particularly, Your Honor, and you'll see in an email, had more stating, and she was absolutely running what was going on. She actually said that I was correct in the readings of the declarations. So, I have other things.
no, and I understand that, but I need you right now to prove your case of why I should proceed forward with one individual when they're acting as a whole.
Because this is the one I can prove that's a board member.
Your Honor, fiduciary duty is not pled. That's not before the court today. And as Mr. D'Orazio just told you, he's here seeking breach of the declaration. If Your Honor were to proceed, in any judgment that's rendered would be against one individual board member. That's not how it works. If there's a problem with an association vote of the members, again, this wasn't a vote of the board of directors. This was a vote of the individual homeowners. Then the proper mechanism is to sue the association if there's a problem with how a vote was conducted. Board members additionally, in addition to fiduciary duty not being pled, board members are immune. They're volunteers. They're protected by volunteer immunity. There's no standing to sue them individually either for breach of fiduciary duty. And again, and I'm going to, I respectfully disagree with Mr. D'Orazio's characterization of why the case was dismissed. It doesn't matter if someone's a current or a former board member. There's either standing to sue a board member for something that members did or there's not, and there wasn't last time and there still isn't. And my attorney's fees affidavit is tab D in the binder. Your Honor.
Okay, and then Mr. Anthony, was this vote conducted by the board or by the members?
The vote was conducted by the members. Called by the board.
Yes, called by the board, but voted by the members.
That's correct.
And the members voted on the painting and everything else that was attached.
Correct.
Mr.
May-
Anthony, do you
may-
have, go
may
ahead,
I-
I'm gonna let you speak, 2 minutes and then I'll let council finish up and then I'll make my
Mhm.
decision. Go ahead, Anthony.
So, but if you read the association declarations are just declarations, and board members, okay, they're the ones that supervise and manage those declarations. If a board member never made a call for a vote, okay, and this board member has a direct interest in the painting. Okay, you got to look at the underlying interest. She has a direct, not every member has an impact. Okay, this board member, if the vote went through, is going to save thousands of dollars. Okay, I don't have any item in this that was going to get painted, so I wasn't going to save $1. Okay, so if you look at the fiduciary responsibility, they called a vote because they knew they couldn't do it under the declarations. Truthfully, they can't call a vote to change the rules of the declarations. So the board member called a vote. She had personal items to benefit by, financial items to benefit by. So they call it to maneuver around declaration. But if you read the declarations, you can't call a vote for that. You have to change the declarations.
Go ahead, council.
None of that has anything to do with the plea of the jurisdiction. Those go to the underlying merits of the case. I'm happy to respond if obviously if the court is questions, but
Okay.
before we can even get there, can this suit even be here? The answer is no. And Mr. Durazio was told this last time and he did it again anyway. There's got to be some sort of deterrent.
All right, so as far as my motion, as far as the motion to the plea to the jurisdiction, Mr. Anthony, I am going to grant that motion. Unfortunately, if you want to sue one board member, there is a whole, and you've been told that multiple times. We have legal aid out in the hallway, and you can seek any legal advice. But by your own comments, she's the only one that I could get or prove. That doesn't justify your means. She may, I don't know what the status of the case or the merits of the case are, but as a board member, they're a group, they're not individuals. So even one has more pull over the other, you can't sue just one individual just because you have more evidence to prove her as being the culprit. So at this point, I'm going to grant the motion for the jurisdiction or plea to the jurisdiction.
All right. So if you guys were following along, this guy's upset about a paint job. Something's getting painted in the HOA, and he wasn't happy with the vote. So he's taken the he took one HOA member to court instead of the entire board, which is what you're supposed to do. He didn't do it, but he's about to get hit with something really hard right here. But this is just HOA. This screams HOA. Oh, you guys aren't going to listen to me in the HOA. I'm going to take you to court. Really? Yeah, no HOAs. They do have their benefits, but yeah, I guess you don't. Yeah, very few when it comes to all the headaches you get.
And counsel, go ahead and talk to me and make your pleading on your attorney fees.
And then, Your Honor, I have also, I will do that in a minute, and I do have an order for Your Honor too. May I approach?
Yes.
Okay. All right. Let me get to my affidavit, Judge.
And you don't have to go into detail, just the general.
Sure.
They could put liens on your house. I don't know if the HOA themselves, I don't think have jurisdiction to actually foreclose on your house, but they can put liens on your house to cause issues. I don't know if liens can actually cause a foreclosure though. They might be able to. I don't know.
How long you been practicing,
Yeah.
your amount, stuff like that.
So I'm an attorney licensed to practice Texas in law since 2018. My practice for the last 5+ years has been in civil litigation, including specifically in Bexar County. I also specialize in POA and HOA law. Attorneys from my firm and other support staff have spent the following hours on this. Attorneys spent 6.3 hours defending against this legal action at an hourly rate of $250 for shareholders. Associates are at $235. And I've had 1.3 hours of support staff time in the hourly rate of $115.
Yeah, but that would mean that your loan would have to be through the HOA. So the HOA can't directly cause your home to be foreclosed on. Now the liens, they could file the liens on your home to maybe cause the bank to issue a foreclosure, but unless you actually get your loan through the HOA, if the HOA acted as their own bank, the HOA can't actually file the foreclosure. It would have to be through another party. That's how I understand how the loans work and how foreclosures work.
So the total amount of fees I'm seeking are $1,844. These were necessary and reasonable.
All right. I will go ahead and grant the plea to the jurisdiction, and I will grant $1,500 in attorney fees.
Thank you, Your Honor.
Thank you, guys. Okay, counsel, here you go. And thank you for being prepared. And then, council, I will go ahead and get my clerk to seal it. If y'all want to hang tight for a minute, y'all can have a seat right here. You'll get a copy of it.
Absolutely.
Everyone's got 21 days to do whatever they'd like. We have legal aid out in the hallway, Mr. Anthony, or you can obtain your own attorney, either which way, okay?
I'll hang out right.
Yes, if y'all want to just have a seat, then go ahead and get to
You,
the next.
you would
Thank
just say that though.
If you want, if you don't want to wait, if you want it email, you can give her your email, or you can do it, we can mail it out, either one.
Yep, thanks.
May we be excused, Your Honor?
Yes. All right, Mr.
All right, real quick on that last case. This is he just got slapped with $1,500 in attorney's fees. Yeah, this HOA male Karen again. I used to call him Ken's, and I was told that was wrong. Then I called him Darren's. I was told I was wrong. So I'm just gonna say male Karen from now on. Took his HOA to in front of a judge, and he got slapped with $1,500 in attorney fees. Hilarious. David, thank you so much. Member for 2 months. That is awesome. Thank you so much, David. You know what's also awesome? A Biggin raid. Thank you so much, Biggin. I appreciate it. Please, nobody spoil the last clip that he was playing. See, it's about 8:20, so I'm about 20 minutes behind on that clip. So I want to see what that lady gets in trouble for, because I know it's going to be something, and I have a feeling she's going to freak out about it. So no spoilers, please, because I cannot wait to go back and watch it. Anyways, thank you so much, Biggin. And yeah, welcome to all the Raiders. Okay, let's go. We're just doing a random court Sunday night. Got a bunch of random stuff thrown at you, a little bit of everything. That's what we're doing tonight. So grab your Coke and your popcorn and relax. Let's go.
How about, let's see, Three Rivers Associates, boy, Agent Professional Property Management versus Mackenzie Evans. Ready on
Good
that?
morning, Your Honor. Scotland for the plaintiff.
There's gone. Do I have Mackenzie Evans? Mackenzie Evans, no. No Mackenzie Evans.
Yes, I'm here. I'm sorry. My
Oh.
my phone was muted.
Oh, okay, ma'am. Let's see, Mr. Stoutland, have the two of you talked at all, I guess?
No, Your Honor. I mean, we have a default at this point, default judgment, and
Okay.
Ms. Evans filed the motion to set aside the default, but she hasn't presented good cause for her failure to answer, and she hasn't presented a meritorious defense.
Okay.
And it's also untimely.
Okay, so we're hitting everything. Miss
It's true.
Evans, anything that you want? No, I do their motion. This is a motion to set aside the default. It says never served court papers, but this has been ongoing since, let's see, when did we get default?
The default judgment, Your Honor, was entered May 31, 24, and her motion to set aside was filed in July. So it's untimely. It's not filed within 21 days.
Okay.
And the reason, Your Honor, she states in her motion is, I never got the papers. I was never served the papers, she says, and unaware to appear in court. But Your Honor, after multiple attempts at service personally, we were forced pursuant to court order to serve her.
Yeah, this is Judge Goggins. Judge Goggins still does his Zoom room old school style where he just brings everyone in at once. He's one of the few judges that still do that. Most people keep them in the waiting room now and just bring them up when their case is called. But yeah, I don't think he's had any trolls in his courtroom, so he's still oblivious to what happens when you do this. That's what I'm going to guess. But anyways, we can still hear clearly, so that's all that matters.
By alternate service, mail, tacking, certified mail, and it went to exactly the address that appears on her motion, Your Honor.
Yeah.
So I'd suggest she did get the papers, Your Honor, and her defense, the only defense she suggests is that she was in an abusive relationship and being stalked, which we're very sympathetic to, and so was my client. So when she said this to my client said, no problem. Just you have to get me a copy of the personal protective order or police report, which, Your Honor, exactly what's required by the statute. MCL 554.601B. Unfortunately, she didn't do that then. And Your Honor, she didn't even do it now. So it's really just her say-so, which is not adequate per the statute. The statute is very explicit about it. You must give this stuff. And there's a good reason for that, of course. So it's untimely. She knew about it. It was delivered to the exact address that she's told the court she lives at in many different forms. And she hasn't complied with the terms of the statute to walk away from a lease. So there's a valid lease, Your Honor, that she just left my client stuck with.
Ms. Evans, in fact, I was looking for paperwork just to make sure how it was served. And I did order alternate service based on postal verification to your address, 5119 Calkins Road, which is the same address you used for your motion. I'm having a hard time understanding how you didn't get notice of the paperwork. Ms. Evans, you got to unmute for me there.
I said I haven't lived at that address now for over a year. So
Why-
when I came up there to do the motion, I just kept the same address because that's clearly what y'all already had. So I should have used my new one. And I thought I told the lady at the desk about it, but I most definitely have police reports that I can show you.
They're not going to give legal advice. My staff isn't. For
No.
one
I
thing,
was telling her my address. I wasn't asking her for advice.
But why would you use that same address? That makes no sense. Absolutely no sense.
That's what I'm saying. I told her my address, but I didn't put it on the paper. It was already written out once I, so.
This looks like it's in your handwriting. Motion is set aside. It's all handwritten in pen, blue pen. Looks like the same penmanship all the way through, and then you signed it.
All right, to clear up some of the confusion, what is going on here? The lady, the former tenant, just left a lease. She just moved out in the middle of a lease, and the landlord went through the eviction process, filed everything that he needed to. Now they're trying to collect the money off of it. She is claiming that she was in a domestic violence type relationship, so she was forced to leave the residence. Here's the problem. She didn't show up to the eviction hearing or the money judgment hearing, whatever the type of hearing it was. She didn't show up for it. Then when she filed the stay so she could have this hearing, she filed the address that she left. She filed the address that she's trying to claim she can't go back to because of the relationship she was in. So that's what's going on here. So she kind of just got herself in trouble. The judge sees it. The attorney sees it. Now we're going to listen to how she tries to justify this.
I did.
Okay, well then you put that address on there.
But I don't live there to receive mail. You guys already had that address.
Okay. And
but I most definitely do have police reports. I most definitely have evidence. So whenever
I've got nothing attached to find good cause for any reason to set aside your default. Numeric
okay, well I can
defense.
give police reports to you.
I'm sorry?
I can't have my police reports given.
It's way past that point.
So what's the point?
Well,
the only reason I moved out of River Forest is because they told me that if I came back with police reports that I could move out. If it wasn't for that, I would have stayed there and I would have did my lease term. It was for the fact that it was the simple fact that she told me if I came back with my police reports, I gave the leasing office my police reports and she told me that it was okay. So now I'm coming back with this, and she already got all of my evidence. But I could come to you with it too.
Yeah, and unfortunately, I got to follow the rules for everybody. Summons was filed, that you were served properly. Everything I see in the file shows proper service, even up to through today's motion. It's got the same address. I ordered alternate service.
I hear a second court coming in. I might have an editing mistake. I'm hoping we'll get through this, but we might not. We might have a normal editing mistake on my end. Let's see.
At that address,
Yeah, welcome, Judge Slavin. All right, fast forward about 10 seconds. Hey, I caught it early this time.
Send an order out to both of you, okay? All right. Good
Thank you,
luck.
Your Honor.
You're welcome. Good luck, Ms. Evans.
What happens now?
No, I think I fast forwarded too much.
Served properly. Everything I see in the file shows proper service, even up to through today's motion. It's got the same address. I ordered alternate service at that address.
Excuse me, Honor,
I've
if I'm not
ma'am,
correct.
ma'am, it's my turn, okay? Then no answer to the complaint, no meritorious defense has been alleged that I can give you any credit for. Motion to set aside the
I
defaults
wasn't
tonight.
fired.
Thank you, Your Honor.
You're welcome. I'll send an order out to both of you, okay? All right. Good
Thank you,
luck.
Your Honor.
You're welcome. Good luck, Ms. Evans.
What happens now?
The default stands. That judgment still stands there. So you hold
What stands?
the judgment we entered, the default judgment.
Wait, so I'm confused. So you're telling me I still gotta pay after
Still
I just
gotta
tell
pay.
people that I got evidence?
Ma'am, you still got to pay. You should have followed through and filed an answer on the complaint, okay?
I'll be back before you, Your Honor. Thank you.
Okay, good luck.
All right, yeah, what county? I don't know what county. It's Judge Goggins is in the Flint, Michigan area. I don't know exactly what county it is though. But yeah, no. So there is, I'm guessing, I've never been in this situation, so I don't know, but apparently there is a clause in a lease that if you're in a domestic violence situation, you can leave the lease and you have to bring the police reports to your leasing agent and they will cancel the lease for you. Or, I mean, I'm sure you have to jump through a few more hoops than just that, but she didn't do any of that. And then she didn't go to court when she was supposed to. So there was a lot of things that she didn't do. So, I feel bad for her that she was in that situation, but you can't just claim that, you were in this kind of situation, so you had to leave, and then that's it. You have to do a little bit more work than that. Okay, next clip. I think we have Genesee County. That's right. Thank you, Leanne. All right, I think we have one more with Judge Goggins. I think I did 2 in a row for Goggins. Let's go.
How about Pasadena versus Princess Williams?
I'm right here.
Williams got you,
Good
and
afternoon, Your Honor. Laura Kirby on behalf of plaintiffs.
oh, this is where we got some variation.
Yeah.
What? Okay.
I can't even hear.
It's not mine. I don't have any others. Those are the only. I can't tell where that's coming from.
I can't either. Wait, let's see. This is notice of hearing motion to stay eviction. Miss Williams.
That's not mine.
This looks like one, Miss Williams, you did yourself. It says motion to stay eviction. I'm not sure what that's for. Go ahead and tell me why it would stay the eviction.
I just needed more
That's
days
not a
because I
Pasadena
was.
case. Excuse me.
Oh no, it's mine. It was a previous Pasadena case that Levine was handling, and she filed a motion to set aside the judgment. So
It was a Levine case at one point.
I'm assuming so. It's in
Back
my file.
July 16th.
Correct.
I'm ready to proceed. If Ms. Palace, I guess, is there some confusion or something?
There is, Your Honor. If we could pass that, as long as I have to go in a breakout room with the manager, maybe I can straighten it out with her. I'm going to the breakout room with the manager for that other case.
Okay, I also have an attorney though that's from Levine's office. Am I putting both of you in there or what's?
She can go ahead and speak to her. I'm actually going to double check with this case if you give me a moment, Your Honor.
Okay, so let me I tell you what, let's just pass on and I guess just interrupt me one way or the other, okay?
Wait, so what am I doing?
Yeah, Ms. Williams, you're kind of just stay right there for just a second. The attorneys are kind of trying to figure out handling it.
Your Honor,
Yes.
Miss Judge Goggins, this is Michelle from Pasadena. Princess Williams filed a motion to stay while Pasadena was with Swiss Stack Levine.
Yep.
They switched firms mid everything, and some of the cases, all the new tenancy cases were with pallets. So if we can proceed with Williams, with Swistack and Levine, and then after that, if I can go into the breakout room with Miss Pallets to discuss the Holmes case. Does that clear everything up for everybody?
It does for me, but I don't.
For me.
That's fine with me, Your Honor.
Is that
I also applied for assistance too. I meant to say that.
Ms. Lawrence, hold on though. You're kind of a different situation here. Hold on. So I guess we can proceed with Levine's office handling Princess Williams' motion. Is that Ms. Crowley? Is that?
That's good with me, Your Honor.
Okay. So Ms. Williams, let's go back to you. This is your motion to stay eviction. Why?
Yeah, there's so many people talking. It is confusing. Now, yeah, there's not a lot I can say about this. There's a little bit of attitude. When I say a little, there's a lot of attitude about to come out, and that's why this is in here. But it's confusing. The apartment complex switched law firms after she filed her motion. The tenant filed her motion, so that's where the confusion is. And I think we got it settled. I think we're good. Let's go.
What's your reasoning for wanting me to stay the eviction? Help me out.
My house was broken into. That's how come I didn't have the funds to pay at the time. Now I'm able to pay the money today, because I had seeked assistance through DHS. They paying partial of I don't even know how much I owe now, because I can't log into my portal to see. I'm hearing they added this month rent, so I don't even know the total no more. I don't know what's going on.
Okay. I'm
a victim of a home invasion. That's the only reason why I'm in this courtroom. I pay my bills on time. I couldn't afford to bounce back that quickly after getting robbed for all my money. I do have a second job now, though. I can't even hear because this man's phone in here.
Okay. Counsel, I guess for me, this was it was a hearing. We had entered a judgment for the total 2,242.06. She did file the motion within the time period for I guess it's an appeal. So
Correct, Your Honor. This is based on
Empress 12 Strings. Okay, that is Empress 12 Strings is your new name. The at Twilight is just everyone knows that you can't be the Empress of the 12 Strings at sunrise. It has to be at Twilight. But so Empress 12 Strings, welcome.
Hold on a second. I had a hard time reading her motion. It was handwritten.
Yeah.
However, the home invasion occurred in April, and she did appear for her first hearing on the 18th.
Yeah.
And then just didn't appear for the hearing on the 16th. And like you said, it's beyond the 10 days statutory period anyway. So at this time, plaintiff is requesting that you deny this motion to set aside and then allow us to file for an immediate order of eviction.
Wait, I'm not understanding none of this because it muted out.
Okay. What the attorney for Pasadena is telling me that we had the hearing back on July 16th, 2024. We entered a judgment for that amount, 2,242.06. I set a writ of eviction date for July 26th. As far as I'm concerned, you filed the motion
within the proper time.
Yep. Right. So that's where we're at right now. But right now, I'm not hearing any reason why I should set aside the judgment.
Oh, there is no need now because I have seeked assistance. Their DHS is paying $628. That leaves me with $1,122.60 and I have that money to pay. But I am confused with what's going on now.
Well, I assume, unless counsel tells me something different, they're going to be requesting an eviction, right? Immediate eviction, since we're past that time period.
And why is that? And I put in the proper motion. Is no one hearing me? My house got broken into. I'm on behind because it was a string of robberies in Pasadena. I was the seventh home broken into. I have the money to pay. I have the money.
Okay,
I have the money.
They may not want the money now. I don't know.
So why is that? Like, what just happened that fast?
Ms. Crowley?
Yes, Your Honor. Ms. Williams, you had an opportunity to appear at the last hearing on the 16th and argue for this.
I came on the 16th.
No, you were not.
I was there July 16th.
Oh, okay. I apologize. You were there, but this wasn't, you had an opportunity to litigate this and express your concerns, and we received a judgment on that day, and you had 10 days from that date to get approved with your assistance and pay, and you still have not. It's the 13th, and I'm well aware that you've gotten approved, but again, we haven't received anything from that rental assistance program.
They switched managers at my complex office. I don't even have the same managers I was dealing with. I was dealing with a Rachel. I go in there to talk to somebody. We got a whole different management. So my thing is, I have the money to pay. So I'm not understanding what.
You didn't have the money back on July 20th by July?
No, because I get paid every 2 weeks, so I needed more time.
All right.
And DHS, I attached some files to that motion. Like DHS did not mail that document back in time.
Okay.
And then I attached the documents to the motion. And I would have had assistance from DHS, but they didn't mail the paper in time. And that's attached to the motion.
I'm going to stick with what my order says, though. Unfortunately, it had to be paid by July 26th.
But you said if I file a motion legally, my court date will be today.
And we're hearing your motion right now, and I'm still saying for everything you're.
And I did, so I don't understand.
Well, I'm telling you that the judgment's going to stand, and they can file for the eviction. They want an immediate eviction right now since it's past that July 26th date. That's where we're at.
I'm not understanding. So they don't want the money. They won't be out of my house.
Right.
For what? How is that legal? My house was broken into. I didn't have no money for them now. I got the money now because I get paid every 2 weeks, and I have the money.
Okay. I understand what you're asking for. Judgment stands. I'll allow a writ of eviction. Okay.
Thank you.
Well, I'm not understanding this. How is that possible?
Ma'am, I just told you how it's possible.
How? Because y'all told me I could legally file a motion. That was my right. I
And
filed
I'm
that
hearing-
motion within those
I'm
10
hearing-
days.
Ma'am,
And they gave me this court. If I would have known I had to come, that lady at the courthouse told me not to go to that court date. Go to this one. That's what she told me down there at your office, at the Flushing District.
Okay.
She filled out that paper. She told me to go to the motion court date. Don't go to the 26th. Go to the one today.
The motion is today, and I'm hearing you.
So how come y'all telling me I was supposed to be in court on the 26th? When nobody told me this. That lady told me to disregard that and go into effect with the motion. Your clerk told me this.
My order stands just as it states. July 26th had to been paid by that date. I wish
She gave me a new court date.
I wish I could help you out more, but today's date stands. I'll allow a writ of eviction. In fact, what's the date today? Tuesday?
It's the 13th.
I'm sorry?
Hold on, I'm not understanding none of this bullshit right now. You telling me I'm getting evicted and I got the damn money right here in my hand, and y'all telling me I didn't put out because your clerk told me not to go to that court. That's what you telling me.
Your Honor,
That's what you telling
Your
me.
Honor,
All right.
what I suggest to Ms. Williams is that even if we do apply for that writ, I do suggest that you talk to the property manager. She may be willing to work with you and accept your payment today if you have it.
The property manager has changed. This is what I'm telling y'all. I don't even know these people. I don't even know who the new people is. I went up there and the lady told me she'll see me in court today. Is she online? Is the Pasadena office lady here?
She is here.
She told me she'll see me in court. She told me I went up there and talked to them, and she told me she'll see me in court today.
Hold on. Is there, if I just, rather than do an immediate writ, if I give her a little time, is that even going to make sense for everybody? I don't know. I don't know who I'm even talking to. Miss Palace, I guess you're taking
I
over.
don't have any authority at this point, but as long as the manager is here and I have to speak with her and there has been some confusion, if I could just speak to her and find out, and we can talk to Miss Carr, and we'll bring Miss Carr. I don't know how to pronounce your name. I am sorry, Laura.
That's okay.
Maybe we could bring her in and work it out.
I'll tell you what, let's do this. Why don't I let Miss Palace, Miss Kirby, and Pasadena, Holloway, let the three of you, I'll put you in a private room first. Let the three of you talk first. And then if you want Ms. Williams back there, you just let me know. But right now, why don't I put you both, all three of you, since we're right on the middle of this thing right now, let's just do it right now.
I'm still lacking understanding here.
Ms. Williams, just sit tight for a minute, okay? I'm gonna let the attorneys.
Everyone is trying to help you. Everyone has heard what you have said. The key thing you just said was you have the money, you can pay it today. Now, all the attorneys have to do is talk to the manager and see if they will allow that to happen. There was some confusion. The judge is trying to help you. Both the attorneys are trying to help you. Even though they're on the opposite side, they're trying to help you. Take a deep breath. Take a deep breath, Miss Princess Lady. It's going to be okay. You can't yell at people. You don't want to get in trouble for when people are trying to help you.
Talk first, okay? Just sit right
They
there.
out there doing insurance scams and frauds. That's how they keep switching managers every time. I don't know what they got going on.
I'm gonna
drive out there, man.
Hold on. I got her muted, and I'll put you 3 back in the room, okay?
Your Honor.
Okay. Let's see.
I don't think I've edited this out. I really don't. Hopefully, I fast forwarded right now. But I know I didn't, do the fade in, fade out. Yep. All right. Let's see how good my fast forward skills are.
Lisa Gibson.
Sure, I got you. Let me just default. Yeah, it would continue from that.
Okay.
Whatever.
So, Ms. Williams, I just want you.
Here she comes.
There we go. Yeah, that wasn't too bad. Yay, editing. That wasn't
All right,
editing.
Ms. Williams, are you there?
Yes, I am.
Okay, and the attorneys are back in here as well. Again, based on what you're telling me, they've discussed, and rather than.
Yeah, she left work. She said she left work. She's headed to the management office right now. I am not getting evicted. I'm going to go beat down their door. She's mad.
Rid of eviction immediately. What they're offering, I guess, is a 10-day statutory time period. Is that right? Whoever's handling that, I guess, Ms. Kirby, are you?
Yes, Ms. Williams, you can pay. You said that you have payment today, so if you want to pay, you're good to go.
You telling me to pay off the money and then get put out?
No, no. As long as you pay, then you won't be evicted.
Okay, that's why I have the money.
Okay.
I had to work for the money. I'm a single mom. I got robbed.
Okay.
Okay, so why don't we do this for me then? I'll grant motion to let's do this. Amend the judgment and to amend judgment. And then I guess, Ms. Kirby, are you still handling this particular case then? Is that what we're doing?
Honestly, Your Honor, I'm not entirely sure, but I can amend the judgment and submit it.
Yeah, can you do that for me? Showing the amount owed of whatever it is. It was we're still using the 2,242.06.
If that's the amount that's still owed, then yes. But if there is anything that's been accrued, then it would have to apply with, I'm assuming, August rent.
Yeah, it would continue from that.
Okay.
Whatever.
So, Ms. Williams, I just want you to be aware that the payment has to include the August rent for you to be able to stay, okay?
What's the August rent? I can't log into my portal.
Well, I will let you know. Actually, if you can contact the property manager after the hearing, she will give you an exact number.
And if I
You
may,
said 10 days. It'll be 10
Ms.
days.
Williams?
It'll be 10 days from today because I get another check next week Thursday. So with that 10 days, that would be within the 10 days. Because I'm pretty sure it'd be another $800 or $900.
Okay, next Thursday would be within the 10 days, yes. You have until the 23rd, so you have until next Friday.
And Ms. Williams, there is a new manager and she's very nice to deal with, so I'm sure that. Okay.
Yeah, she won't tell me she'll see me in court on the 13th. That's why I thought everything was pay the money and just go about my life. I just got really upset.
You know what? Let's just put this. Let's just put this behind us and move forward, please.
Yep. So what I'm going to do is expect. I was going to do it. A new judgment that will show, I guess, include August rent in there. Okay, and then with a writ of eviction after 10 days from today, I guess it'd be the 23rd.
Thank you, Your Honor. Will do. I'll submit that today.
Okay. All right. So everybody's all set, Ms. Williams.
I had a question.
Okay.
DHS to pay that $620. They said they're gonna pay the $620 by the 20. So if I pay this month, how much I owe today? I think it was 13 something. I need to know what was the half off of the 622.
I can't help you with that.
I don't know what it is.
Why don't you go in and pay what's owed now, and then pay what you owe now, and then there'll be a balance due, and you'll have to pay that right away as well within the 10. Yes.
Okay. That's what I want to know. Yes, ma'am.
But don't wait, because money tends to disappear.
Mine don't. Look, hey, I'm gonna go get the money order right now. I done left work. I'm so upset.
Okay. All right.
Great. So I just got down to motion.
Money tends to disappear. That was, I feel like that might have, maybe it's just like a spending thing, a budget thing, or you just told us you got robbed at the beginning of the hearing. And as she said, my money doesn't disappear. Yeah, you know what? It does. It does. I guess you just keep cash in your home. Anyways, she's getting what she wants. She's going to get to stay as long as she actually does have the money. But she said the magic words, I can pay it today. So everyone tried to help her out. They didn't want to see her get evicted if she has the money. So hopefully she paid.
Motion to amend judgment is granted, includes August rent with a writ after 10 days. Okay.
Thank you, Your Honor.
All right, guys. All right.
All righty. Thank you.
All right. You're welcome. Good luck to everybody. I guess you, Ms. Williams. Thanks.
All right. We're moving out of Judge Goggins' court. We can't do too much of that. I feel like that's his courtroom every single time he's on. It's just people yelling at each other. That if they just had a calm conversation, his docket will take 2 hours instead of 6. If everyone was just calm and talked and explained things. All right, let's move on. Let's get Goggins out of our head. Let's move on from landlord tenant.
0433FY, People State of Michigan versus Antoine Burris, ANTWAUN.
Purpose on behalf of the people.
Okay.
Good morning, Your Honor. May it please the court, my name is Greg Mortimer, and
I think you wanted the super chat just so I had to attempt to say your name. Why do you do this to me? Cheshire Cat. The Cheshire Cat. The Cheshire Cat. Thank you so much for your $2 super chat. I appreciate it. And yeah, that it does happen. Money does disappear. Cheshire. I'm gonna practice Cheshire.
represent Mr. Burris. We're here today for PCC. Oh, I'm sorry, I'm standing in for Russ Donaldson, who's the attorney of record.
Okay. Can
Your
you
Honor.
file an appearance for yourself?
Cheshire Cat. Cheshire. But see, when I say it fast, it comes out the same way. Cheshire. Oh man. Yes, I know. It's the cat from. That doesn't mean I can say it. I think that's just one of those words I'm gonna have to chalk up that I can't say. Cheshire. Yeah. All right, let's go.
Mr. Donaldson?
And
I don't think. So here's a green sheet. All right, yes, we are here for a public cause conference. What's your name, sir? All right, and so the charges are controlled substance, possession of. Rewrite up there. Less than 25 grams.
I can say that one. Wash your sister. As in wash your sister sauce. See, I'm good at this. Yeah, see? Wash your sister sauce.
Some type of controlled substance, and I believe it's cocaine. So that is a felony carrying 4 years, $25,000 fine, and a misdemeanor driving while license suspended, carrying 93 days, $500 fine, and the driver's license sanctioned in the form of points, suspension of the license, and possible vehicle immobilization. So of course you do understand your charges there, Mr. Burris. Okay. And on this matter, you have a right to have a preliminary examination within 21 days of your arrest.
All right, I don't want to hurt your English ears. It's Worcestershire. I call it Worcestershire or Worcestershire. I I grew up. It was Worcestershire sauce. So yeah, I call it wash your sister sauce because that was the I don't know that video that went viral when the lady called it wash your sister sauce. Yeah, so it's a joke now, and I'm gonna call it that now. But yeah, I'm sorry to hurt your ears.
Agreement and within 7 days of today's probable cause conference. So you understand that? Okay. All right, and so how would you like to proceed today?
Your Honor, we'd like to set the case for exam. Mr. Donaldson asked me to adjourn the PCC, but since I'm here and I've talked to Mr. Burris, and considering this case as a rewrite, Mr. Burris would like to have the case move along as fast as possible. I do know that there's some discovery Mr. Donaldson has requested. I think it's a video. And I'm sure that Mr. Shockley can get that to him soon. So we would ask that the exam be scheduled as soon as practical.
All right, how many witnesses?
Going to be one witness.
Okay, one witness exam.
Court's available September 11th at 10 a.m.
Thank you.
All right, September 11th, 10 o'clock. Mr. Burris needs some fingerprint and here's an order. 4 fingerprints.
Your Honor, he tells me he was fingerprinted when he got rearrested.
They just asked me, they said they don't have it. So, step across to police department, check on that, we would appreciate it.
Your Honor, Mr. Burris has advised that he doesn't want to waive his 21-day.
Oh, well, okay. He doesn't have a choice because we don't have a date for him. So I'm gonna waive it for good cause.
Okay. I signed the next year now.
Okay, I need to go back to this case to see, is they trying to say something else? Okay, let's go. Is there something else? No? Mr. Mortimer, anything?
Osmodius. Thank you. I like saying that. Osmodius. Thank you so much for becoming a new member. I like your name. It's fun to say. Osmodius. Thank you so much for becoming a member. Welcome to the family. I sure do appreciate it. Oh man, there's Bacon coming out. I sure do appreciate it. All right. I forgot we're kind of watching court right now. I'm sitting here practicing saying words while I'm on mute. What's going on right now is this defendant, he had his case. It was dismissed without prejudice because of a witness failed to show up. Then it was refiled against him. So he's trying to assert all of his rights to try to get it dismissed again. So he's saying, I have a right to have my preliminary hearing within 21 days, and I'm forcing that. The judge can say, yeah, no, we don't have a date. Like she said, there's no possible way. We're not pushing it out because, just because. We're pushing it out because there's absolutely no time to do this. So she can find probable cause, not probable cause. Is probable cause? That's not the right term, but you know what I'm saying. So she can push it out and waive that up for the court's discretion to do it. So it's on the court. It's not on the attorneys, and that's where that rule falls onto. So he's trying to get it dismissed because his preliminary hearing is scheduled a month and a half out. Yeah, not going to work, man. But he's about to throw some attitude.
No, the only thing, Mr. Burris just wanted to make that statement about the,
You can't, I understand.
Right.
Do you know how many people want a preliminary examination?
I do, Your Honor.
Every single case. We have no time, sir. We're booked all the way up. Through September.
Just kept being adjourned up and down on PCC for 11 months. I was over back and forth.
Well, so what do you want me to do? I'm not your lawyer. I don't know why your case was adjourned before. I don't have any recollection.
Then I just get rearranged. They send it, I take you.
Yes, that's what they do. I can't do anything about that either. That's the prosecutor's discretion. They decide if they want to rewrite the case once it's dismissed for whatever reason. And maybe it's dismissed because somebody witness wasn't available or wasn't here. I don't really know. I don't recall. But that's what they can do. They can rewrite it because it wasn't really adjudicated.
Said what the process ain't being fine.
Sir, what is it that you want? That is all due process. You get rewritten, you've been through an arraignment, you understand the charges, you're about to have a preliminary examination, which is a statutory right. It's not a constitutional right. So there's no due process issue there. What is it that you're looking for?
Probably cause conflict. What else is dismissed?
No, that's not what the rule says. It doesn't say it's dismissed. And guess what? If I did it, you'll be right back here again with a rewrite. If I were to do that, and I'm not going to do that because that's the rule doesn't say. It just gets dismissed if it's beyond 21 days. I might have dismissed it previously because somebody wasn't available and that was the date they should have been. But I don't know. I don't have a recollection of it. But I don't dismiss cases just because we're gone beyond 21 days, especially when it's due to court congestion. Okay, sir, what do you want me to do? I can't do what you want. You need to talk to Russ Donaldson, your lawyer, about all of that. If he thinks that there's some relief you've got in some kind of form, he will file a motion. But I'm telling you, I don't see the motion. But you can talk to him about it. But I can't do anything for you because it's been 11 months since the whole thing started and then it got rewritten. There's nothing I can do. But if you hold on, you'll get some type of a assessment on your exam date as to where the case is going. That's all I can tell you. Okay.
Thank you, Your Honor.
All right.
Enjoy the rest of the day.
Sure.
All right. Yeah, that just happened. Yeah, no, Judge was spot on. Yeah, I don't need to explain anything else. I do have some big news. You guys want to hear some big news? I have weaseled my way in, is probably a good way to say it, to a jury trial of a sovereign citizen on Tuesday. Not going to say which sovereign citizen, not going to say what trial, but I have gotten myself a seat for a Sov-Cit jury trial on Tuesday. So I will have a very special show to show you guys on most likely Tuesday night, depending on how long it is. But I'm really excited about it. And I believe I'm probably the only person that's going to have this footage. So yeah, look forward to that. Look forward to that. Tuesday. I believe it's set at 8:30, but the way that the courts usually work probably won't start till about 9. And depending on, it's a Sov-Cit, so it's probably going to go for 3 or 4 hours, as I would assume. But we'll see. We'll see. So you guys might not see me too much on Tuesday. I might not have any regular videos out, but I'll have a great show Tuesday night. This is what I'm hoping. This is what I'm hoping. Now, he still has to show up. I could be saying this and he doesn't show up for court, which is a fear of mine. But I'm excited about it. So, yeah, we're going to do it. Okay. All right, next clip. That was my big news. That was my big news. Okay, let's go.
Is there a man here who's a translate?
No,
Somebody else. So.
For non-trial appearances, I'm comfortable interpreting for my client, but for trial and hearing purposes, I would need an interpreter.
Okay. Well, we got a motion
How did you guys figure out it was Eric Martin that quickly? Seriously? Yeah, it's the Eric Martin jury trial. He's in his jury trial is set on Tuesday, and I have talked my way into being allowed on Zoom, so I will be grabbing the footage. So that's what's going on. And yeah. Yeah, I know. You're not dense. I know. I know. Yeah, it's Taylor. It's Taylor. It's Taylor. It's yeah. Anyways, I've got a Zoom invite, so I'll be hanging out and I'll be watching it. Anyways, we finally get to see Eric Martin represent himself in front of a jury, and I'm really excited about it. But again, he has to show up. This is my biggest fear about saying things like this is I'm gonna make this big deal about it, and then he won't show up. This was about a month ago, maybe a little longer than that. I was so excited. I had, I think, 4 different sovereign citizens on my schedule for the week. And I was really excited. And I announced it on Monday. It's like, I've got a sovereign citizen on Tuesday. I've got 2 on Wednesday. I've got 1 on Thursday. Out of those 4, only 1 showed up. So it only ended up being 1. So you can't count on them to show up to court. But I think Eric Martin will. I really hope he does. Okay, let's go. Let's go.
To increase bond, and can you put it on the record what summarize what it is?
Yes, Your Honor. The defendant was recently arrested for aggravated assault with a deadly weapon after posting bond on his current the burglary case that he was is set for trial on. He was also arrested for after being on bond for this charge for assault family violence, Class A misdemeanor as well. And the state's requesting that his bond be revoked.
Yeah, I'm not going to do that because it's going to be on Zoom. I'm not going to do that. I'm gonna grab it and then I'm going to edit it down. Like I said, it's probably going to be 3 or 4 hours, and I don't want to live broadcast a court from Zoom. I feel like that's crossing too many lines. So yeah, not I can't do that. That's yeah.
Increase due to those new charges. He's been indicted and on the felony charge, and he is also
felony charge of
the aggravated assault with a deadly weapon, and he's also then information has been filed in a cause number given to the assault.
That's not
family
in
violence.
here though. I don't see this
In the motion to revoke
the
bond.
motion to increase bond.
There may have been a new one. I just filed one last week. Is that the?
Yeah, this is a motion filed February 28th of this year.
You know, Your Honor, there's a new one I just filed.
I don't have it in here.
I'll look to it.
But from the defense perspective, I think it would be wise that we have an interpreter if we're going to have a bond hearing. Aside from that, the presumption of innocence is very strong, and we would rely on that at this point. But if the court would like to set this for a bond hearing, I would
Look, here's the problem. You gotta, if it's an indictment, it's a probable cause. It's stamped as probable cause finding by a grand jury. And that's what the court needs from me in determining whether the bond factor, number one, don't commit another crime. And I want a hearing on this, but I don't think I need a hearing if I have an indictment that's pending and we're waiting around when someone may be endangering the community. Hello?
Sorry.
I'm not gonna just let him amble about. That's another why everybody needs to help out on when we have these. It's not just my burden. Y'all know, I don't know. I just found out. Now, I remember vaguely, but you look at my docket, it's 20 pages long. I can't tell you who needs a translator. Y'all have to tip us off. And so that we can have something prepared on that. And Well, we can get some people, but what is his bond on the new indictment?
It was. According to the motion filed by.
No. I'm not going to be there as a juror. No, I do not live. I don't even live in the same state, so I couldn't be a juror if I even though I wanted to. No, I just asked. I sent the judge an email and asked them if I would be allowed, if they would allow me to appear on Zoom so I could watch the trial, and they said yes. So that's what happened.
The bond was set at 150,000.
That's correct. The bond of the new case is 150,000.
And he made that? I guess.
I have not been hired on that
Yes,
case.
sir.
I do not represent the defendant on that case.
Yes, sir.
But presumably, yes, he's standing here. He's appeared before
Wow.
this court. And
He's preferred. I know. I don't remember an issue of the bond. That always bypasses me on new charges. I'm not in the loop.
same here, Your
Unless
Honor.
there's a motion to increase bond on a pending case. Well,
And as a side argument,
you're hired by him?
I'm hired on the case that mistried. I have not been hired on any new cases.
Okay.
And
What court did that fall in?
Court.
That new case?
Yes, sir.
Do I have an indictment on that? Can I see a copy of an indictment?
I'll call you both files, Judge.
Stand by. I see. Well. What do you want to do today? You're asking for an increase in bond.
yes, sir.
You want a translator, but here's the deal is that there's an indictment that was handed up. That's probable cause. I'm going to take action. I'm going to act on the bond. The bond is going to be increased. That's all I need. What's his current bond? 15,000? Yeah, the new indictment alleges in 24 CR 1407 that on or about June 5th of this year, while the defendant was on bond in cause number 2138753, it alleges that he intentionally, knowingly, or recklessly caused bodily injury to Erica Robledo by striking Erica about the head and body with a metal rod, using a deadly weapon, namely the metal rod, which was capable of causing serious bodily injury or death. So and this is family violence. The actors.
And it's
is
the same
called
victim, Your Honor, from both of those cases, the same complainant.
Which case?
There's an assault bodily injury that while he was on bond as well, family violence. And then also that, and as well as there's some photos, if we have a hearing there, that shows pretty substantial injuries to the victim as a result of the aggravated assault.
What? Yes. It says Class A misdemeanor, November 25th. Huh?
See if I can turn that information.
Did I factor that into a bond in this case? Did I raise his bond or anything before?
No, Your Honor.
Okay.
We ended up having the trial before we dealt. I think I'd filed that, but we had the trial, and then since then this other issue come up, so we filed another motion.
Again, Your Honor, I would ask for a continuance if this is a bond hearing. If the defendant does not speak English and he is not able to understand what we've already said.
Attorney games. These are attorney games. He said at the very beginning of this hearing that he can communicate with his client because we're not at trial. I can communicate with him and he understands what I'm saying. And now that his bond's about to be increased, he's like, oh, we're going to have to adjourn this because we need an interpreter now. Yeah, you can't play it both ways, man. You can't play it both ways. You can't go into the hearing and then now that, oh, they're going to raise his bond and take him into custody. Oh, yeah, now he needs an interpreter. Attorney games. I mean, I'm going to say I'd probably do the same thing if I was in his position. He knew this was coming. He knew this was coming. He saw the charge. He saw the indictment. So frustrating, though. This guy, his bond needs to be raised. It really needs to be raised. And just look at Judge Stevens right now. He's like, I can't believe this. You just told me that he didn't need a interpreter for this hearing, and now you're telling me he does. Anyways, Mayor, thank you so much for the 5 gifted memberships. I appreciate it, bud. I appreciate it. Thank you so much, and welcome to the 5 new members. All right, let's keep going.
And I would ask for a continuance so that we can prepare for a proper bond hearing with an interpreter so that the defendant can understand what's going on.
You speak Spanish? Speak, yes, you're, as his attorney, speak to him. But here's the problem. I've got an indictment that's been handed up. I can't wait on this for the safety of the community. This is an issue that's necessary. And then surprise, y'all spring we need a translator this today. I'm sorry. That puts me in a real bad spot, everybody. And this has happened numerous times this morning. These surprises, I don't like it. And I come from a federal background where that was just never accepted. Y'all got to tip me off, and if there's something the court has to do, but also you have an obligation on behalf of your client to make sure that if there's not one, well, we can move in the interest of justice. We better have one so he understands. I'm not you're making me look like a perpetrator here. I'm not. And this guy is now, we're dealing with now 3 between the burglary of habitation, the assault misdemeanor charge that's pending, and then now the new aggravated assault. Yeah, I'm going to let him amble about the community. I can't do that. Look, I'll have a hearing as soon as I can, and we'll try to get somebody, but y'all have to do something too. If he needs it, I think that the defense attorney, and you're retained on this.
I'm not retained on anything new. But
Are you retained on this case?
Yes, Your Honor.
Then help get an interpreter. And we'll do our best we can get one, but we're going to have to get certified interpreters from Houston, and we'll get here as soon as possible. But he is going to be placed into custody. I have information here, probable cause that an indictment, his bond is $150,000 in this new case. And we'll have a hearing as soon as possible to get this ferreted out. But I'm in a box, and it's not my fault. Y'all have to tip me off, please. It's only the community endangerment is the issue. That's 250,000 people. Everybody's got to be looking out for what we're talking about here. The threat to the community is this issue. And then we just can't say, well, we're going to wait until we ever find a interpreter, get an interpreter around here. I'm sorry, there's a fire. This is a fire. It needs to get put out. And then we can talk about how it started and what should be done. But right now there's a fire, and he's starting the fires. And it's not just an arrest. It's a grand jury indictment rendering saying he did that while on bond. And that has authority on its own. Anything else?
Your Honor, just to clarify, I guess you said it's bond 150,000 in the new case, which it is in the aggravated assault, but I guess the one we filed the motion to increase on is the burglary that was already.
That's increase. That's
Okay, that's the
that's
one.
all.
Just to clarify, I just wanted for the
That's the
record.
only
Yes, sir.
issue here. It's the
Yes, sir.
burglary. He was charged with a felony offense. Now a grand jury has indicted him for committing a violent crime while on bond. And we could wait if truly, what are we going to wait for? Years?
Thank you so much for putting that in my head. Thank you so much, Mac. All right, let's knock out some of these. We got, hold on, we're way back. Darina, we got a lot. We got a couple more since Darina, 7 months. 7 months, that's awesome. Rich, 8 months. Thank you so much. Jedi, 7 months. Thank you. Sly, 4 months. And Carla, 2 months. You guys are all awesome. I know, Sly, you've been here longer than 4 months. Carla, thank you so much for the 2 months. You are awesome. Everyone else just meh. Carla, you're the VIP here, not the people with the bigger numbers. I'm just kidding. You guys are all awesome. Darina, Rich, Jedi, Sly. You guys have been here since just about day one. I appreciate you guys. You guys are awesome. Thank you so much. And yeah, let's keep the party going. Now this clip is about finish, or this clip is. I think this is what ends it. I don't think I have another clip after this. Let's see, we're at 1 hour exactly. The video is 1 hour and 4 minutes. So yeah, this is the last one. So we're gonna listen to Judge Stevens essentially go off on the attorney right now. But yeah, that's all I got for the night. Told you guys the big news for Tuesday. Tomorrow night is Members Monday. That's all I got. That's all I got. You guys are awesome. Thank you so much for hanging out with me tonight. Thank you guys for the milestones, the gifted memberships, the super chats. You guys are awesome. I really appreciate it. And yeah, have a great rest of your Sunday. I'm glad you had a safe weekend, because if you're here, you're not in jail. So my warning on Friday, hopefully it worked. So yeah, we'll see you guys tomorrow. I always feel like I have something else to say, but I don't. I always want to keep talking. That's my problem. That's why I talk too much. All right. Again, thank you all. You guys are awesome. I just looked at my list to see who I could potentially raid. My list is zero. There's nobody that's live right now on my subscriber list. So I don't. If you guys have any suggestions, I'll look the channel up real quick. The way that I have my setup is they have to be subscribed to me, though, so I can't just go to a random channel. Like even if I'm subscribed to them and I watch them, I can't raid them unless they're subscribed to me. I don't know if that's how all of YouTube works, but I've noticed that's how my list works. So anyways, you guys have a great rest of your night. I will not be in Discord tonight. I'm going to throw that out there. I'm going to go spend the rest of my evening with Heather. She's been away all weekend, so I'm going to go spend some time with her before she goes to bed. So you guys have, again, so many times. You guys have a great rest of your night. Let's just end it. Thank you all. Until next time. Bye.
Until we find a translator? No. Gosh, it's just, I'm very aggravated here by being put in a spot of surprise. Everybody needs to help on this.
May I respond, Bill?
Yes, you may.
Your Honor, me and Mr. Boyd talked about this case on Friday.
This court's determination, but go ahead. What did y'all say?
On the issue of an interpreter, and it was my understanding that we did not have an interpreter scheduled, and that today we would be kind of shelving this issue and revisiting it once we got an interpreter scheduled. That was my understanding.
Okay.
I was not prepared for a bond hearing today.
All right, good enough. I've already made my order. I'm happy to rescind it, but it'll be on the state's back. Now, if you want to wait until an interpreter arrives, that's fine, but it's your request, not mine. If that's what the state wants, I'll do that. What are you asking for? You asked for a motion. I didn't hear you say, no, let's don't have a
Yes,
hearing.
sir. Your Honor, Mr. Gilthorpe is aware. I mean, we deal with this issue constantly, and their defense attorneys are aware that they need to notify the court anytime their client is on the docket who needs an interpreter.
I know you're saying things I already know.
Well,
what are you saying today? Are you asking the court, based upon what he said, to rescind my bond ruling on this and hold that in abeyance until we can have a hearing? It's your
No,
call.
no, Your Honor.
All right. There. You're asking to, for what we have without an interpreter to
Yes,
move
Your Honor.
forward. It's done. That's what we've done. But let's try to get an interpreter so he has a hearing.
Yes, sir.
But there's a fire. We don't have time to negotiate on the price of the hose. There's a fire that needs to get put out right in this moment. That's the second separate assault that's been committed while he's been on bond in this case. Now tell me that that's not a problem. And one of these has been reviewed by a grand jury. Okay. That is all. Next event. Next event. Trial. What was it sent for?
On the original case, yes.
In the original case, it was sent, it was an announcement, set for trial.
We're ready.
Thank you. Okay.
And Your Honor, we would just ask that both of those be set on the trial docket. The new case as well. We have provided that discovery to
He's
Mr.
kind of
Gilton.
be fair. He's got a fair chance to get ready. But let's get, you still want a hearing on the bond, and that's okay. Let's get a hearing and get a translator as soon as we can. This week if possible. Thank you.
Your Honor.
And it'll help us out. Anybody knows somebody, or if you're willing to agree, the orange lady, that's great. I don't know who that is.
May I
but
have a few moments to explain to the defendant?
You got all the time? Yeah, go ahead. All right. All right. Bring him back into the jury room. Grand jury, the jury room. Thank you.